Okay, now I'm going to continue. Discovery plan. Well, the discovery plan, remember we talked about with the strategy for legal and have a discovery plan, right? What would you do? For a ROG, right, if there is a divorce action, protected party may have other motivation for filing restraining order, right? So if you notice that the accuser is also filing a divorce, a lot of time having a restraining order would kind of give them a heads up. No, not a heads up, like a advantage, because now my client has to move out and this accuser gets to stay in the primary home or their home. Child custody might be one of the things they would do, because now my client moving out and she's claiming that my client was abuser, then my client would have to be ordered stay away from their children and her. And then so you always want to see if there's any motivation behind this when someone accuses your client of a restraining order. And you request for admission to see if you get the party admit anything. Request for possession of document and other tangible thing like the text. Nowadays, it's always text. People hardly talk on the phone now. So look at the text message. If the accuser is saying that I am so scared of your client, he's making all this threat, but in the text, she is saying, oh, I miss you when you're coming home from dinner and stuff like that. There's no sign of fear, right? So you should look at the text message. Sometimes it's voicemail transcript, also photo. And you can also take a deposition of your client or the accuser or any other relevant party that can help you dissolve this restraining order against your client. Okay? So now you go into the hearing. It's like a mini trial, okay? So you bring your witness, you prepare your trial exhibit. One of the questions is that should the client respondent to testify or not? Should your client to testify or not? That's a tough one. I think that a lot of times they get very emotionally involved, that I don't think that the best witness, especially if you find out that there is a criminal charge against your client, not just a family court. And like I said early on, if there's a criminal charge against your client, I would at least continue the case till the criminal case is over, because I wouldn't want my client to say anything or admit anything that can harm them in their criminal cases, the Fifth Amendment, right? So it's against self-incrimination. So if that was the case, if there is a criminal charge, I would wait till that criminal charge case is until the criminal case is done. But if there's no criminal charges, just a family court, I never encourage my client to testify unless you think that your client would be a really good witness and can be thoughtful and not be emotionally passionate about making a statement. Sometimes it hurts them. So that would be your judgment call, and how much you know your client and trust your client would be a good witness, right? And again, I would continue if there's criminal charges, because family court typically always subject to continue the family court restraining order until a time after the criminal court has complete its criminal hearing, because you totally understand why. So don't be afraid to ask. Okay, so now we want to go through a couple hypothetical questions. I think the best way to learn is actually being interactive and give you some, well, even though they're hypothetical, it's pretty much cases that happen with our office and how we handle it. And then so I think that's the best way for me to give you all a good example. So then when something similar, obviously there's no same cases, not all the cases are the same, but at least you can see what my thought process is and see how we handle a case like that, okay? So let's read the hypothetical question. I'm going to give you some time to read it, and then we can have a discussion. So client come in for initial consultation. Client informed you during consultation that he has had prior restraining order against intimate partner in the past. Client informed you that his new wife has retained a famous attorney that is high profile. Client informed you that he had threatened you with email to kill new wife in the past while they were engaged. Client informed you that he has an emergency protecting order issued against him in addition to the temporary restraining order. Client is also a physician in the state of California. What do you advise clients? Okay. So before we talk about strategy of the case of this hypothetical, I just want to let you know, if you are a physician, a doctor in California, if you have restraining order against you, the clerk of the court will report directly to the American Board Medical Board. So if you are professional, you might want to check with your board, because a lot of time having a restraining order against you would have to be self-report, or they do get this information which is negative effect on your license, professional license. Okay, so remember we talk about what are the effects that can affect you if you get a restraining order. This is one of them, which I think we mentioned that on those lists. Okay, so how are we going to deal with a case situation like this? I would say that stop contacting the new wife at this point. No more texts. And then I will go to one by one. What was the meaning of the text? How that happened? I would also make sure that we talk to the opposing counsel to see if we can settle in any way and drop the case. I would also find out if there was a divorce case is being filed. If a lot of time the client doesn't even know what's going on, a lot of times they were surprised by it. What was their last gathering or out? What happened? And find out if there was a divorce being filed. Is there other motivation behind this, right? And then I would see the prior restraining order. Why would there a prior restraining order? And what was the story on that? And then so how that played out with the current situation was the same fact. Those are the stuff that I would ask. And then also I created a discovery plan at the same time. So I was doing my legal strategy, and at the same time I had to figure out what my discovery plan would be. So, right? Okay, so let's go on the other hypothetical question. Hypothetical 2. Take a time to look, and then we can talk about it, discuss it, and see what we can do on that, or how will we handle a case like this. And I swear, none of those are, even though we say hypothetical, but it really happened. So I think the best way to learn is actually dealing with a real problem, a real question. So those are the real case. You have retained a difficult client. Your law firm has continued the domestic violence restraining order hearing 2 times amid this COVID-19 safer at home crisis. Clients insisted on going to court to complete the hearing and prove that he is not the abuser that his girlfriend or accuser claims. You have caught client multiple times in a lie. Surprise, surprise. Client has told you that he never threatened to harm his girlfriend, and girlfriend's attorney sent you many emails and text message, which the client also denied them that are true, which evidence client threatening in the recent past 2 months to stab girlfriend and to kill her, right? So she's making all this threat. Client then insists that he does not want to settle because he's quote unquote innocent, and instead he wanted to testify to the court to share his side of the story. that this was all joking, nothing was serious, and that he was just admitted in the text because they got in a fight, to break up, and he just wanted the girlfriend back. How will you handle this case, and how will you advise your client with a situation like this? I'm going to give you a minute and we can discuss. First of all, I don't think it's a good idea for my client to testify, right? Which we talk about that, unless you can find tons of evidence to show that the accuser was making all the false statement. But like I said, the client never tell you the whole entire story. So even though this client say he's shocked, he doesn't hurt his girlfriend, but opposing counsel handed you with all the many texts and email and voicemail that our client is threatening a client, threatening the girlfriend. So what you do with that? Well, you find out what's going on. You ask for continue. That's number one, and you get a deposition ready. I would say, first of all, if there's any other motivation for the girlfriend to do that, how the relationship, how long they've been together, where they live right now, where's the girlfriend, to see even the recent texts. In this case, the text where the client admitted all that in the text message was because he wanted to have his girlfriend back, and his girlfriend just wanted him to say sorry, admitted that he was not a good boyfriend, he had bad temper, and so on. So the admission, the text isn't necessarily my client physically beat her, but it was the word that you saying that, would you admit that you are abusive? And my client just wanted to have the girlfriend back and admitted, say yes. So again, those are the response that we need to address in our responses. But with the COVID-19, again, none of us want to go into court for health reason and to protecting our family and other. Unless it's truly emergency, we often advise not to go to court for the safety of other and our family. We have contacted the opposing counsel to see if he or she would continue the case, especially my client actually do not live in the same state as their client. So there's really no emergency at this point. And number two on that, because the court have announced that unless it's truly emergency, the court is not going to hear any cases at this point during COVID-19. The opposing counsel is being reasonable and trying to work with us, and then maybe we can prolong the willing to continue with us, which the TRO would continue till the next hearing. So there's no concern for her client's safety issue. The counsel refused to continue. So again, my client live in different state. But there is a TRO. We just want to continue the hearing so that we can be more prepared and address every statement of the accusation. We wanted to have an opportunity to depose the client, or at least get a witness statement, or interview more witness to see the incident if that is true. Especially we got a bunch of texts and email, which we didn't really get the whole story of the text. The text that we got in the exhibit was very choppy. So yes, there was a threat saying that I wanted to kill you, but when I asked our client what was the full story on that, he showed us the rest of the text, which showed they were joking. She said, "You're gonna cook for me," and then he was joking back and he said, "Well, you thought my food was I was a bad cook and you wanted to kill me. Unless you don't mind the way I cook, I don't want to kill you with my food or my cooking skill." that's what the full story of that text was. But however, obviously in the petition, what opposing counsel have sent us, the evidence was more favored to, if you're just looking at part of the text communication, it looked like our client was the bad guy and wanted to kill their clients, to kill their client. And again, attorney wanted to make money out of the billable hour, and sis going to court and thinking that this is an emergency, even though my client living more than 100 yards away from her client, a different state, we might you, and we do have the right to continue one, and the attorney refused. So we had to go to court on this, and the judge did give us the continue. So it was just a waste of time and waste of the resource for our clients, and I'm sure their client also. Okay, let's look at the next hypothetical. Again, even though it's all hypothetical, the real cases, we kind of changed the fat a little bit, and obviously confidentiality, we don't disclose the name, but those are the cases that we often had to deal with in family law, especially with domestic violence. People always all high emotion, and especially with COVID-19, with court are closed, except it's truly emergency cases, is very, it's always very emotional and difficult to deal with those type of cases. And again, if your client have not a U.S. citizen, is immigrant, you always want to double check with them about the immigration status, because having a restraining order can also affect their immigration status, right? So it's very important. Our client, most of them are international client, international student, so we do deal with the immigration status a lot. So that's one of the things that we always make sure we ask our client about, because we wanted to make sure that having the domestic violence order does not affecting their immigration status later on if they want to adjust. And also professional people having restraining order against them can also harm them in their professional association or board or license. Okay, let's go on to the next one. Sorry, I just wanted to give you guys more tip protecting your client when someone come in. This is a reminder. Hypothetical 3. Okay, I'm going to give you a minute to read it, and then we can go do it together. Okay, so this is kind of like the case that we dealing with hypothetical, but it's more dealing with COVID-19 right now, just because everybody's very confused. The court order keeping changing. We keeping getting update of what's going on with the local court, Riverside, Los Angeles, San Bernardino, Santa Ana. All the court have different rule. And right now, like I said, all court are closed unless there was an emergency cases. And what considered to be emergency cases? Well, in family law, restraining order would consider emergency. However, obviously for the safety of yourself, your neighbor, your family, we always try to avoid going to court unless it's necessary. We have a client that coming in and just got served with TRO, and the restraining order was going to happen in 5 days. And again, 5 days is not enough to prepare for the response and to get the whole story, not including the weekend, that 5 days. Especially the petition declaration was 300 pages, which a lot of them were witness statement declaration and email communication and their texts. So there's no way we can be ready and file the response within 5 days and still going to court while the COVID-19 is going on, and we have to wear masks going to court and put all safety on the line for that. So one thing we ask is that can we ask for continuance, and then because the opposing counsel refused. I guess they wanted to make the money, or they wanted to go. So we tried to call the court and then to see if we can get continuance or do court call instead of physically being in court. The problem is that right now, a lot of family court have closed down from 5 department to 2 department, and some of the court that only hear one cases. For example, I recently had to go San Bernardino courthouse. It was 5 or 6 family court down into 2. And then the day I went to court, it was only 1 department that was listening to restraining order hearing, and it was not even a home judge. So every court is different. And we've been trying to call the court. This has happened to be in Los Angeles Appeal Court, and there was no one answered the phone. And it's very frustrating because there also doesn't post the court. The LA Superior Court does not post any number where you can reach for emergency hearing or phone number we can call to set up a court call if it's necessary, or do we have the permission to do so. And then when we called the court, that the number that have listed on their website, there was no live person picking up the phone. So it's very frustrating, but just let you know that the good news is that if you decide to file written response, the court does, at least with LA Superior Court, does accept fax filing. So that's one good news. If you decide that a written response would be okay, is necessary, and you can get everything on time to do so. Again, in our case, I never suggest that because we literally only have 5 days before going forward. And at that time, we did not know if we can do court call, we can reach anyone. There was no live person. And the petition declaration was 300 pages where we didn't even have time to really address each or every accusation that was against my clients, and that was the reason we wanted to see if we can continue. But the good news about this case, this is a real case. The good news about this case is that the emergency hearing was on Monday. On Friday afternoon, early afternoon, around 11, opposing counsel finally come to their senses and willing to continue because I guess they realized that there was more incident of the COVID-19 that being affected, and realize that's not worth it going to court for something that which we could have resolved and tell the next hearing. Okay, so now I'm going on the next last hypothetical question. So this is kind of similar to, not similar, but this is kind of like, the reason why I was telling you, always find out the motivation behind it. When someone accuses your client in saying that there was domestic violence, there's restraining order, I always wanted to know if there's any motivation behind it, because I also have clients that come to my office, was actually the other side, and ask for this. Client tell you that petitioner filed a TRO against him to gain leverage on child custody, a visitation order, and spousal and child support order. Because in family law, if there is a domestic violence, you need to pay for child support, you need to pay for spousal support, and so on. Client is, and then you would have protecting order where you would have the most custody time with the children because abuser would not be able to see the children, right? So because you can file a restraining order as you and the children as a protected person. So this is the reason why I talk about that. Hold on, let me see. We have a question really quick. Okay, I have a question about that because we talk about motivation. So one of the question is, address the issue motivation with a petition, bring a DVRO petition as a leverage in another civil lawsuit related to a business deal. I guess I need more on the question. what do you mean by civil lawsuit? Because this in a family law, DV is a domestic violence is intimate relationship. So are they bringing another civil lawsuit that is not in the family law? So if you don't mind, please write your question, give me more the full story so I can try to answer that. And then I know there's another question that is, if the doctor cannot practice, how can the doctor pay spousal support and child support, assuming maintaining a lifestyle that other spouse and children are accustomed to? Good question. Exactly. And this is the reason why I always tell, and which we can come to hypothetical 4. In my hypothetical 4, I actually have clients come and tell me this. And when the client come and trying to do this, the person he or she, I'm gonna try to be confidential, trying to do that, the person who's being accused is the sole provider, and it's actually a famous doctor, and that was making most of the money and then taking care of the family. So I made that very clear. I said, you sure, or are you telling the truth that your husband or soon to be ex-husband is a violent person, abusive to you? Because if there is a restraining order against him, that it will affecting his practice, which he's the one who support the lifestyle and so on. So yes, this is what happened where, let me finish. I don't know if you guys finished reading the question. The client's complete shock by the TRO and the new divorce against him. Petition declaration are all centered by child custody investigation issue and what clients tell you false allegation of child abuse. There's no DCFS open case. Clients that petition handed him the TRO. The TRO hearing is set to occur in 3 days. Clients confused about everything. What do you advise? Yeah, and so a lot of time I will also reach out to the opposing counsel and say, you know, my client's the sole breadwinner, and for you to do that, you do understand there was a loss of income. So yes, that does affecting their income, but you know, if that affecting their income, remember child support and spousal support is based on their earning. So it's also going to hurt their client regarding for, it's also going to hurt their client receiving the spousal support and child support also. Okay. And this question, if there's no pending divorce case, is discovery permissible in the DVRO? Yes, it is for the restraining order. So you can do that. That's fine. Okay, deputy bankruptcy court adversary case making false claim in DVRO to gain advantage in BK case, bankruptcy case. Respondent plaintiff in bankruptcy case has not had contact with petitioning over 2 years. TRO was denied, but hearing set for June. Petition does mention the bankruptcy adversary case. I'm not sure about the bankruptcy case. I don't know how, because this is mostly family law, so I'm not sure how that have any effect in the bankruptcy court. So I can look into it. Maybe we can talk privately so we can see how that works. But I think that's what you were mentioning earlier about the civil lawsuit, right? Okay. So we can talk about that some other time, and time is up. And sorry, I can't answer that bankruptcy court because I'm not very familiar with bankruptcy court. And so I don't know how that's going to affect the bankruptcy court hearing. Okay. Again, if you guys have any question, feel free to contact me. And this is our information. So please feel free to send me a private email and just call me. I would be glad to answer. And the question about that bankruptcy, I would love to discuss with you. At least you can tell me how it works in the bankruptcy court, and then I can see if our family part or the case in family hearing would help your client's case in bankruptcy or not. How that related. So let me know what you're looking for in the bankruptcy, and then I can see how we can help on the family side. Okay. It was so nice to meet all of you. And again, if you have any question, feel free to call me or send me email. I would love to help you and discuss. And I can also learn something too. Thank you.